Have you ever signed a listing agreement to put your house on the market and nobody ever went over the paperwork with you? Here's an important video that goes through our listing agreement paragraph by paragraph, and you need to see it if you're thinking about selling your property. This crucial information is coming right up. I'm Steve Reese, a realtor in the Oklahoma City metro area, specifically the suburb of Shawnee, just east of Tinker Air Force Base. I run the SoldOnShawnee.com real estate and community blog. I'm deeply involved in the advocacy and property rights through the local, state, and national associations of realtors. And on this channel, I tell you everything you need to know about relocating to the Oklahoma City metro area. So in the age of digital signatures and emails, the real estate industry could really do a much better job of counseling sellers through the listing agreement. It's an important legal document, and I don't want technology to be an excuse for not making you an informed consumer. This listing agreement is a product of the Oklahoma City Metropolitan Association of Realtors, and it was last revised in July of 2020. So if you're looking at a document that's earlier or later than that, they're similar, but know that there'll be differences. I'm going to put myself in a little circle up here and bring up the document so you can follow along with me. All right, we're looking at an exclusive right to sell listing agreement. The effect of the listing agreement means that you've appointed us as your exclusive broker. We will represent you. You funnel any leads or inquiries or purchase offers through us. We will handle all of those for you exclusively. You'll pay us the compensation that we've agreed to down in the body of the contract. Paragraph 2, the sale of the property means that upon completion of the sale, at closing, you will have transferred ownership of the property to the next owner. You no longer own it. Paragraph 3, we describe the property through its legal description and a street address. And a property refers to land and any improvements affixed to it. So that's your house, a barn, outbuildings, fences, that sort of thing. And attached to those would be these attachments here. So the attic and ceiling fans, bathroom mirrors, other mirrors that are attached to the wall, light fixtures, carpet and tile, window treatments, keys to the property. So look over this list. If there's something there that you would not be leaving with the property, we need to make sure that we exclude that in the agreement, and so that prospective buyers know that as well. Something that's not covered here that we need to talk about ahead of time and make sure that we know what's going to happen with our TVs. So TVs mounted on the wall are mounted with brackets, and brackets leave holes in the walls. So if you plan to take your televisions with you, we need to decide whether you're leaving the brackets or taking the brackets. If you take the brackets, we need to make sure that the holes are filled and painted accordingly so that there isn't any evidence of there being a bracket or a hole there before. Alternatively, you could leave the brackets there for the new owners, or you could even leave your television for the new owner and upgrade when you move to your new home. Paragraph 4 is the listing price. Of course, I will give you good counsel with data and figures from comparable sales, and we'll arrive at a listing price together. Ultimately, that's your decision, but we'll use the data and arrive at a number that makes sense. Paragraph 5, the term of the listing agreement. So it'll commence on a certain date and it will expire on a certain date. Paragraph 6, broker duties and responsibilities. So I have the following duties and responsibilities to you, the party, which are mandatory and may not be abrogated or waived by the broker. I must treat all parties with honesty and exercise reasonable skill and care, which I don't need the law to tell me to do. Subparagraph 2, unless specifically waived in writing by a party to the transaction, I must do these things down here. So let's talk briefly about that. There are limited service brokers who will only do some very basic things that they're required to do, and others that they're able to waive with an understanding of the party. I'm a full service broker and will not be waiving these things, so these will apply. I will receive all written offers and counteroffers. I will reduce offers or counteroffers to a written form upon the request of any party to the transaction, and I will present timely all written offers and counteroffers. Subparagraph 3, timely account for all money and property received by the broker. So keys to the property, security codes for the security system, earnest money, all those things will be accounted for. Subparagraph 4, keep confidential information received from a party or prospective party confidential. So that's you, the seller, and a buyer. Those Things include that a party or prospective party is willing to pay more or accept less than what is being offered, that a party or prospective party is willing to agree to financing terms that are different from those offered, the motivating factors of the party or prospective party purchasing, selling, leasing, optioning, or exchanging the property, and information specifically designated as confidential by the party. So in C, the motivating factors, those might be that there's a change in your family status, your family is enlarging or contracting, or there's a change in a job situation, something that's affecting you all to move would be considered a motivating factor. Unless that was published in the newspaper or made Facebook public by you, then it would be considered confidential, and I would be bound to keep that in confidence unless you give me written authorization to disclose it. Subparagraph 5, disclose information pertaining to the property as required by the Residential Property Condition Disclosure Act. So that's something else I'm required to do. If there's a defect of the property or something that affects the property adversely, I'm required to disclose it if you haven't already disclosed it. Subparagraph 6, comply with all requirements of the Oklahoma Real Estate License Code and all applicable statutes and rules. B, brokers shall have the following duties and responsibilities only to the party for whom broker is providing brokerage services in a transaction. They're mandatory and may not be abrogated or waived by a broker. I am to inform you in writing when an offer is made, and that the party will be expected to pay certain closing costs, brokerage service costs, and approximate amounts of the cost. So I will give you an estimated net proceeds worksheet, and that'll come at the time of listing and also with any offers given to us that differ from that amount. I will keep the party for whom the broker is providing brokerage services informed regarding the transaction, so I will stay in constant communication with you. Paragraph 7, bottom of page 2, duties when working with both parties. So I have the ability to work with both parties, a buyer who may contact me to view the property and then subsequently make an offer on your property. That's allowable by Oklahoma law. However, you will be notified of that and given the opportunity to know about it before you accept the offer. And the same thing with the buyer. Everybody just needs to be aware of what's happening. Seller acknowledges that broker, I don't know why they put this in here, but at this place, but nevertheless, seller acknowledges that broker is not an expert with respect to the law, tax, financing, surveying, structural condition, wood infestation, hazardous materials, or other matters requiring expertise. Seller is encouraged to seek expert assistance concerning such matters. Okay, the bottom of page 2, paragraph 8. Compensation to broker. Compensation is in consideration of the service performed by the broker. Seller shall pay the broker a percentage or a dollar amount, and we'll decide on a percentage amount to put there, and we will be offering a portion of that to the buyer's broker for bringing us a buyer and a purchase contract. When earned, it's earned any sale of the property by the seller to anyone at any price or on any terms. So during the terms of our listing agreement, if you decide to sell the property to somebody or somebody comes to you, that would be earned. Paragraph 2, the broker or in cooperation with another broker through our multiple listing service or otherwise, finds a buyer ready, willing, and able to buy, option, or exchange the property at the sales listing price or any other price acceptable to you. Or the seller breaches this listing agreement, including without limitation the removal or withdrawal of the property or any portion of the property from the market, and then contributes, conveys, or transfers the property or any interest therein to an individual or firm during the term of the listing agreement. It's payable when the compensation is earned. The compensation is payable either during the term of the listing agreement or after its expiration or termination at the earlier of the closing of any sale of the property, seller's refusal to sell the property after the sale compensation has been earned, seller's breach of this listing agreement, or at such time as otherwise set forth in the listing agreement. D refers to an extension period. So I'm just going to say, for instance, if within 90 days after the term of this listing agreement you enter into a contract with a buyer who's been shown the property, we will give you within 3 days, for example, after the termination of this agreement, a list of those names of people who have been shown the property during the listing agreement, and if one of those people were to buy the property, commission would be earned and payable. Subparagraph E, other fees. If a buyer or a party with whom the seller has entered into a contract for the sale of the property during the term of this listing agreement breaches such a contract and seller receives earnest money or a portion thereof as liquidated damages, seller will pay broker the lesser of 1/2 of such amount or the sales compensation. Any amount paid under the subparagraph is in addition to any amount the broker may be entitled to receive from any subsequent sale of the property. So that's just basically saying if there's a contract the buyer has breached and we retain the earnest money, we would be dividing that for liquidated damages. Paragraph 9, disclosures required by the seller. The seller will deliver to the broker the disclosures and notices as required by law. The seller must complete the required disclosures or notices to the best of your knowledge and belief. You authorize me to furnish prospective buyers and other brokers with copies of all required disclosures or notices. So we're talking about the property condition disclosure and a federal lead-based paint disclosure. I'm not just going to turn you loose with them and leave you to it. I will guide you and show you how to fill it out. They're a little tedious, but not impossible. Subparagraph B, seller shall promptly amend the applicable disclosures and notices which become outdated or inaccurate. So if something changes and needs updating, you agree to update the disclosure. You acknowledge that I have the duty to disclose to any buyer any defects in the property actually known to me which are not included in the residential property condition disclosure statement. Subparagraph D, seller will protect, defend, indemnify, and hold any and all brokers harmless from any and all damages, costs, attorney's fees, or expense arising from the seller's failure to disclose any defects of which seller has actual knowledge or information of as required by law, or communication of any incorrect information to any and all brokers. So basically we just disclose what we know and we can't go wrong. Paragraph 10, definitions. So broker means the real estate broker, associate broker, sales associate, provisional sales associate, anybody with a real estate license who is performing these services. The brokerage services means the services that we're doing to market your home and provide sales transaction services. Subparagraph C, the term party means you, the seller, or the buyer. The term transaction means the activity to buy, sell, lease, so on. Such activities or processes may include without limitations soliciting, advertising, showing or viewing real estate property, presenting offers or counteroffers, entering into agreements, and closing such agreements. All that refers to a transaction. The term firm means a sole proprietor, corporation, association, or partnership. That's just the licensing category that our broker is. Okay, we're on page 4. Paragraph 11, listing of the property. The broker is a member of the multiple listing service of, and in this case it would be MLS OK. That's a multiple listing service that's headquartered out of Oklahoma City, owned by our board of realtors, and that covers a large part of central Oklahoma and some outlying areas as well. The broker is authorized to file listing information about the property with MLS for processing and dissemination. Also, you authorize me to place information about the property on the internet, either directly or through a program of the MLS or other listing services. So we, through the MLS and through other programs, information about your property will be syndicated to many other websites online. Paragraph 12, access to the property. You're going to authorize us to get access to the property either with a key or some other means, usually a key. And through that, we're going to access the property at any reasonable hour and authorize other brokers, inspectors, or appraisers to access the property at any reasonable hour. What's not mentioned there but will happen in the purchase agreement phase is a surveyor, but they won't go into your house or inside of the property. They'll just be on the outside. Subparagraph B, a key box. So you're probably going to authorize us to put a key box on there, and we'll check is or is not authorized. I highly recommend authorized so that it just makes it much easier and quicker for agents to get in to show the property. There are 3 options here. Only one of them is correct. The Supra is their current manufacturer of our MLS lockboxes right now. A combination lockbox or keyless entry. With a Supra lockbox or an MLS type lockbox, those are battery operated, use Bluetooth to communicate with mobile apps that every member has, and it will give us information who was in the property, approximately what time they unlocked the box, and approximately what time they locked it back again. So we know about when they were in the property and for how long. Best form of I hate to say security, but at least verification of who was in the property and gained access to it. You don't get that from a combination lockbox. So some agents will use those, particularly when they're operating outside of their normal marketing area, just because it's less work for them. But a combination lockbox doesn't do anything to protect you. They're easily broken into, and we have no information about who's in the property. So never allow anybody to put a combination lockbox on there unless it's just for a very short period of time for a specific purpose. Keyless entry would be if you had a keypad on your lock instead of using a key all the time. So that many of those are now Wi-Fi enabled or whatever, and great convenience for you, but they do nothing to help protect us from not knowing who's in the property and at what time. Also, if an agent is just using that and a buyer happens to look over their shoulder and see the code, then somebody who's definitely not authorized to access your property has the combination to your house. Same thing could happen with a combination lockbox too. So only one right answer, the Supra MLS lockbox, no combination, and we want to stay away from the keyless entry if possible. If you have a key or can get to a key, we want to do that and put that in the lockbox. Paragraph 12B2. If the property is occupied by a tenant, you're going to get a written consent from the tenant to allow us access to the property at those reasonable hours. Number 3, seller acknowledges that you understand that neither the lockbox system, the key box, the key to the key box, nor any other component or aspect of the lockbox system is designated or intended as a security device or system. And designated probably should be designed or intended as a security device or system. Number 4, seller will protect, defend, indemnify, and hold any and all brokers harmless from any damages or claims arising from authorizing access to the property or the use of a key box, including but not limited to damages to or loss of real or personal property or personal injury not caused by broker's negligence. Seller assumes all risk of any loss, damage, and injury. It's an important paragraph. It's not anything we love to talk about, but it's the reality there. It's going to be a part of any listing agreement and something that you may want to talk to your insurance agent about if there's something additional that needs to be added there. But we just need to understand these things that I'm going through with you. Paragraph 13, broker's authority. Broker is not authorized to execute any document in the name of or on behalf of seller with respect to the property. You authorize me to advertise the property by means and methods as I determine in my sole judgment and discretion, make and use photographs or other electronic images of the property, place a for sale sign on the property, remove from the property all other signs offering the property for sale or lease, and at seller's expense turn on or leave on until closing or termination of this listing agreement all utilities or have service persons to do so in order to show the property and permit inspections. So all utilities must stay on during the entire listing agreement, and once we have a purchase contract during that until closing, so that we allow for all the inspections and people to gain access to the property. You authorize us to furnish sales information about other properties to any prospective party. So a buyer is going to want to be an informed consumer as well, and may want to know what similar properties have sold for recently and what other similarly priced properties look like. And so they will be furnished that information as well. G, disseminate the information about the property to seek assistance from and offer compensation to other brokers providing brokerage services to the party. So that may be through a multiple listing service or for a non-MLS participant, but another agent, licensed agent, we would be giving them information about the property and helping them gain access to the property. H, have access to the property at any reasonable hour to show the property to any prospective party. 13I, we're now at the top of page 5. Obtain all information pertaining to any present mortgage on the property from any holder, any note secured or lien. So you'll let us know of any lien holders. If you've had a heat and air system put in and they file a lien on the property, we need to have information about that so the title company can make sure that's recorded and they're paid off before we transfer ownership. Of course, a mortgage loan will need that information for the title company. J, upon the closing of a sale of the property, to submit information about the property, sales price of the property, and information that allows others, appraisers and other agents to use this property as a comparable when they're evaluating the value of a similar property. K, upon termination, expiration, completion of performance of the transaction and or closing of the sale of the property, except as may be provided in a written brokerage agreement between the broker and a party to the transaction. The broker owes no further duties or responsibilities to the party after termination, expiration, expiration or completion of performance to the transaction, except to account for all monies and property relating to the transaction and to continue to keep confidential information confidential. L. Accept earnest money and deposit the earnest money in a trust account in accordance with the terms of the contract for the sale of the property. So we receive earnest money from a buyer and we either deposit that into the broker's trust account or into the title company's trust account. Paragraph 14, seller's representations. Except as set forth in paragraph 18 below, seller represents that. You represent that you have fee simple title to and possession of the property and all of its improvements and fixtures. So you basically have the right to sell the property. You are not now a party to another listing agreement with another broker for the sale, exchange, option, or lease of the property, and no person or entity has any right to purchase, lease, or acquire the property by virtue of an option or right of first refusal or another agreement. D. The property is or is not subject to a mandatory homeowners association. So if it is, we'll check that box, put the amount there per month, year, however it's collected. Subparagraph E. The property is or is not subject to a special assessment, and if it is, we'll put the amount that's unpaid. Subparagraph F. The property is or is not in a historical preservation district. Subparagraph G. Is or is not in a municipal special design district. Also, you're going to represent that there are no delinquencies or defaults under any mortgage or other encumbrance on the property. If you are in that situation, we'll definitely have that conversation. It's not insurmountable. We can get through it. We just need to have all the information so that we can navigate it properly. The property is not subject to any probate proceedings, foreclosure, divorce proceedings, or the jurisdiction of any court. If it is, not a deal breaker. We just need to know about it so that we can get proper guidance and move forward accordingly. J. All information relating to the property provided herewith or which may be provided to broker by seller is true and correct, and seller will notify broker in the event of any changes to these representations. So if everything's great right now, but during the course of our listing agreement, you're unable to make payments or are notified that it's going into foreclosure or something, let me know and we'll navigate accordingly. Paragraph 15, seller's additional promises. Seller agrees to cooperate fully in good faith with the broker to facilitate showings and marketing of the property. You agree not to negotiate with any prospective buyer who may contact you directly, and provide me with copies of all leases or rental agreements, if any, pertaining to the property, and advise tenants and make sure everybody knows what's going on. And at your expense, again, you'll turn on or leave on until closing or termination of this listing agreement all utilities. Paragraph 16, limitation of liability. So if the property becomes vacant during the term of this agreement, you'll notify your insurance company, make sure that the proper coverage is in place there, a vacancy clause or whatever. Same thing if there's a tenant there, you want to make sure that you've got the proper coverage. Understand that the broker is not responsible or liable in any manner for the personal injury or that sort of thing to the property. You need to make sure that your homeowner's insurance covers it, which it probably does, but it may warrant a phone call to your agent, to your insurance agent, to make sure that they know what's going on. Also, I'm not sure whether it says it there, but unless we have a separate agreement, if the property is vacant, this is an agreement to manage the property or to make sure that everything is the way you want it there. That would be a separate agreement, and probably with a property management company. Paragraph 17, residential service contract. Those have many times been called home warranties. If you'd like to offer one, they can be a good value for you during the listing period. They don't charge you during the listing period, would only be charged at closing after we've contracted with a buyer. Then it gives the buyer a 1-year warranty for certain systems after closing. So it can be some peace of mind depending on the age of appliances and systems of the house. Value for you during the listing period. If we're in 100-degree weather in the summertime and the air conditioner fails you, you can pay a minimal service fee and have somebody out to fix it. They'll either repair or replace it. Usually they'll repair it when at all possible, but it's something that we can certainly talk more about. Paragraph 18, if there were any special information that was referred to up above. One thing that might go into paragraph 18, we might say, see attached coming soon addendum. If we're executing this prior to days before putting it live on the MLS and online and the websites and everything, we may refer to the coming soon addendum. That's something I would put there. Paragraph 19, default. If the seller breaches this listing agreement, but not limited to the sale of the property without my knowledge, and consent. The seller is in default and will be held liable to the broker in the amount of the compensation specified in paragraph 8 above. If broker breaches this listing agreement, broker is in default and seller may exercise any remedy at law. Mediation in paragraph 20. You'll see this also in a purchase agreement. We're agreeing up front that if everything goes sideways and we can't come to a resolution amicably, then we agree to go into mediation. And the state of Oklahoma has a dispute resolution system that's excellent at taking care of these things cheaper and much quicker than filing something in the court system. 21, attorney's fees. So the non-prevailing party would be responsible for attorney's fees if that were the case. In mediation, there are no attorneys. In paragraph 22, agreement of the parties, addenda. So addenda and other related documents which are incorporated into this listing are the disclosures that we talked about, our seller's estimate of expenses, and then any written disclosures waiving broker duties and responsibilities as in paragraph 6, which being full service, that's not going to apply to us. So the addenda that are going to be included are the disclosures and the seller's estimate of expenses. Subparagraph B just says that this is the entire agreement. There's nothing else in it unless we've referenced to it above. Assignability, it may not be assigned to any other party without the approval of the other party. It's the binding effect. It's binding upon and inure to the benefit of the parties hereto, the respective personal representatives, heirs, successors, and permitted assigns. So legally, the document says that if you were to die and you were the only person on the listing agreement, that your heirs would be next to be responsible for the contract. I'm not about holding anybody's feet to the fire that if somebody doesn't want to be in this agreement, certainly if there's a tragedy like that strikes, we're just going to cancel the agreement until everybody's got it sorted out. But it says here that it's so if I were to die, my broker would be the one responsible for it after that. E, joint and several. So all the sellers executing this agreement, even though it may be on separate pieces of paper or all together here, they're all responsible for it. Governed by the state law of Oklahoma. Subparagraph G, if any part of this agreement were to be deemed illegal or otherwise unconstitutional, I don't think that's it, but if it's invalid, much better than unconstitutional. Subparagraph G, severability. So if any clause or any part of this listing agreement is found to be invalid or unenforceable by a court of law, that the remainder would remain in force. Paragraph 23 and page 7 of 7. Counterparts. If more than one person is named as the seller, then the listing agreement may be executed by each seller individually, but it's all considered one agreement. 24, additional notices. Compensation or the sharing of fees between brokers is not fixed, controlled, recommended, suggested, or maintained by the brokers, by our local realtor association, by any group of realtors or brokers together, that all brokerage fees are set independently. Equal opportunity, so properties shall be shown and be made available to parties without regard to age, race, color, religion, sex, handicap, disability, familial status, national origin, sexual orientation, or as may be provided by local, state, or federal laws or regulations. In addition, our National Realtors Code of Ethics states that we will not discriminate based on gender identity or sexual orientation. Paragraph 25, disclosure of offers. So we're going to talk about up front whether I'm authorized to disclose the presence of other offers. So if we receive multiple offers, I need to know ahead of time whether you want me to disclose that up front. Usually, I'm going to say I'm not authorized to disclose the existence of other offers on the property. That would be my recommendation to you, but we will certainly talk about it case by case. 26, waiver. The seller waives the right to receive subsequent written bona fide offers to a transaction related to the property after acceptance of a contract. All that says is that once we have a bona fide accepted purchase offer, I'm not required to present you any subsequent offers. However, I'm still going to communicate with you and share with you anything that happens. If I'm given an offer, you're going to know about it. Just how I operate. And then we date, put our address, sign, I date, put company information and sign. All right.